2022 Hot Topics in Trust and Estate Law. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Travis Hayes, ACTEC Fellow from Naples, Florida. ACTEC Fellow Steve Akers from Dallas, Texas is here today to fill us in on hot topics in trust and estate law, including the proposed regulations for the Secure Act, the estate of Levin versus Commissioner case, the Connolly versus United States case, and the Smaldino versus Commissioner case. Welcome, Steve.
Thank you very much, Travis. The Secure Act, which we got in late 2019, generally provides that amounts in qualified plans or IRAs must be paid out within 10 years rather than being paid over the full life expectancy of the beneficiary. We received proposed regulations February the 23rd of 2022, and I'm going to hit just some real highlights of those proposed regulations. The biggest surprise coming in the proposed regulations is that with the 10-year rule, there must be distributions made each year during that 10-year period of whatever amount would be made if there were a life expectancy payout. We had thought previously, by analogy to some other provisions, that no payments would be due until the very end of the 10-year period, but that's not the position of the proposed regulations. Some good news coming out of the proposed regulations is that they really had some simplifying measures for accumulation trusts. There are two types of trust for which we can look to the beneficiaries of the trust as the beneficiary of the plan to determine whether the plan has a, quote, designated beneficiary so that we don't have to have all the benefits paid out within 5 years. And those two types are a conduit trust or an accumulation trust. With a conduit trust, all amounts received from the plan are immediately paid on out to the beneficiary. With an accumulation trust, whatever is received from the plan can be accumulated in the trust. Some of the measures that we got that are simplifying for accumulation trust. Number one, we got some clarity on what successor beneficiaries of the trust that we have to count in determining whether or not all of the beneficiaries are, quote, designated beneficiaries. And as well, who is the oldest of the beneficiaries. We also got clarification about, for powers of appointment, that we don't have to worry about permissible appointees under a power of appointment and whether or not they are designated beneficiaries, that is, individuals. But only when a power of appointment is exercised do we count whoever is the recipient under the power of appointment. And we got similar rules for decanting or reformation of a trust, that after a decanting or reformation occurs, then we look at who is the recipient under the modification or the decanting. If that happens before September 30 of the year after the year of death, then that is deemed to be, we look at those as beneficiaries as of the date of death of the owner of the account. So for accumulation trust, we got some simplification measures. Another simplifying matter, we can use accumulation trust for minors. There are 5 exceptions from the general rule that distributions have to be made within 10 years. One of those is for minors. The proposed regulation clarifies that means someone under age 21. We don't have to look to different ages of majority in different states, and there's no reference to completing a course of education. So that's a simplification. In addition, the proposed regulations clarified that we can use an accumulation trust for a minor, even if there are others than the minors who are also recipient, as long as the minor is the only current beneficiary, that would still qualify for that exception. We can also use accumulation trust for another of the exceptions, and that's for disabled persons or chronically ill persons. We also got clarification that we can have multiple beneficiaries of trust. We can have multiple beneficiaries of conduit trust or of accumulation trust. Where we have multiple beneficiaries, then we generally would look to the oldest of the beneficiaries to determine the life expectancy payout during any period when we have a life expectancy payout. For some of those exceptions, there are different rules. For the minors, if we have multiple beneficiaries of an accumulation trust for minors, that is no longer qualifying for the minor exception when the oldest of those beneficiaries reaches age 21. For disabled persons, on the other hand, if we have multiple disabled persons of a single trust, it is only when all of the disabled persons have died that the trust no longer ceases to be a, quote, eligible designated beneficiary, one of those exceptions. And then last comment regarding the Secure Act is that for spouses, keep in mind that a standard Q-tip trust will not qualify for the exception for spouses that is in the Secure Act. It needs to be a Q-tip trust to which we've added that all distributions from the plan will immediately be paid out to the spouse, which means that it would be a combined conduit trust and a Q-tip trust for the spouse. That's the Secure Act, several comments. I'm going to make some just very brief comment about the other cases. The estate of Levin, the commissioner, 158 Tax Court number 2, is an intergenerational split dollar life insurance case. Parent advanced funds $6.5 million to a trust so that the trust could purchase life insurance on the life of the transferor's daughter and the daughter's husband. This was under a split dollar arrangement so that the $6.5 million would be repaid at the death of the insured, or if the policy is turned in early or the split dollar agreement is terminated early. The case is very interesting because it has a very interesting discussion of sections 2036 and 2038. The government argued that the entire $6.5 million should be included in the gross estate. The estate argued that while the estate had the right to get back the $6.5 million advance, if the policy was kept until the insured died, that could be 20 years in the future. And so we ought to discount that back to present value. The government argued because of Section 2036 and 2038, it ought to be the full $6.5 million. A key fact in this case was that the decedent did not have the right to join with the trustee of the trust in deciding whether to turn the policy in early or to terminate the split dollar agreement early. That is different than in the Cahill case, and that factual difference was key to the 2036-2038 analysis. The court said that the decedent did not have the ability, in conjunction with others, for example, the trustee of the trust, to decide to terminate the split dollar agreement early and therefore go ahead and get the $6.5 million immediately. Well, even if they didn't have the right under the exact split dollar agreement, what about the fact that the parties to an agreement can always amend it, and therefore they could have got it back early? The court said, looking to the old Supreme Court case, the Helmholtz case, that the mere ability to modify a trust under state law is not enough to trigger 2036, 2038. That is helpful to us in planning limited partnerships or LLCs. We want to design those specifically, not to say that if the decedent is a partner or a member, that the decedent can join with others in dissolving the partnership or doing things that would be tax-sensitive measures. Connolly v. U.S., 128 AFTR 2nd, 2021-5955. This is a district court case that discusses a buy-sell agreement. And it's just interesting, there aren't many cases discussing buy-sell agreements and whether or not they fix the estate tax value. This case did. It concluded that the agreement did not fix the estate tax value. It did not meet the Section 2703 safe harbor. It did not meet the cases and the case law requirements for an agreement to set the estate tax value of stock being purchased under the agreement. And so therefore the court had to value the stock at the decedent's death. An issue in this case is that the corporation was going to buy back the stock in this case. So the corporation had bought a life insurance policy on the decedent's life. The question was whether or not those life insurance death proceeds had to be taken into account in valuing the stock. The estate said no, the IRS said yes, and the court said yes, that it must be taken into consideration. And that was despite the fact that the Blount case, an 11th Circuit case previously, some years ago, had held the other way. The last case I'll mention, the Smaldino case, is just very briefly to say, always be aware of an indirect gift issue. If husband makes a gift to wife with the understanding that wife will make a gift to the dynasty trust, then it is treated as if husband made a gift to the dynasty trust. In the Smaldino case, they tried to do that in order to use wife's gift exclusion amount. It didn't work. And indeed, there were terrible facts in that case. The wife had agreed expressly that she would turn around and give those assets into the dynasty trust. That could be just really devastating if we're not talking about a trust for children, but we're talking about what we commonly call a spousal lifetime access trust, a SLAT. If we want to create a trust of which wife is a discretionary beneficiary, but husband creates the trust, husband's not a beneficiary, so it's not in husband's estate under 2036. It's not in wife's estate because she's not the creator of the trust. But if wife was the moneyed spouse and wife gave assets to husband with the understanding that husband would turn around and give them into the SLAT, this result of the Smaldino case would be there. And so be sensitive to that possibility. Those are a few of the current developments, hot topics, important for 2022.
Thank you, Steve, for updating us on 2022 hot topics and trust and estate law.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.